My name is Paul Thaler. I am the Director of External Affairs for the National LGBT Bar Association. I am sitting here with Darcy Chemnitz, our wonderful Executive Director. As a topic introduction for this important call-in, it is that we will be addressing the Administrative Procedure Act. Our panelists will discuss how the drastic change in leadership and the potential defunding of agencies by the Trump administration can and will affect the many regulations protecting, amongst other things, LGBT rights, access to health care, hospital visitation rights, and clean air. This call-in will also serve as an APA 101, if you will, followed by a discussion on how changes in regulatory law could affect your day-to-day life over the next 4 years. So I'm now going to just give a quick speaker introduction for the 3 speakers that we have on the line today. And again, thank you again to all of you who have called in for this. First is Ken Choe, who is a partner at Hogan Lovells. Ken was Deputy General Counsel to the Office of Health Reform at the Department of Health and Human Services, where he was lead agency counsel with respect to the ACA, as well as Medicare, Medicaid, and other healthcare financing programs administered by the Center for Medicare and Medicaid Services. Ken also has ample litigation experience, particularly in the areas of administrative and constitutional law. He has appeared in state and federal trial and appellate courts across the country and has participated in numerous matters before the Supreme Court. Ken began his legal career as Special Assistant to the General Counsel at HHS. Between his periods of government service, he was a senior litigator with public policy and a public policy advocate, at the national headquarters of the ACLU. Next, we have Jane Perkins, who is a legal director of the National Health Law Program, also commonly referred to as NHeLP. Jane leads the organization's efforts to ensure that health care protections are implemented nationally and at the state level. Jane also manages NHeLP's litigation docket. Jane has provided support to health advocates in all 50 states and nationwide, and at state-based training around the country. Jane has written on Medicaid, child health, civil rights, and federal court access. Jane also co-authors a yearly article for the Journal of Poverty Law and Policy on how the Supreme Court's term has affected low-income people's access to the courts. She has taught health law and policy at the University of North Carolina Chapel Hill School of Law and served as a clinical associate professor in health policy at UNC School of Social Work. And lastly, we have Len Sandler, who is a clinical professor of law at the University of Iowa School of Law and director of the Law and Policy Action Clinic at that school. Len's work with the clinic is award-winning. He designs and supervises community-based projects focused on disability, civil rights, health care, transgender rights, housing, transportation, and other matters. ADA accessibility and universal design in housing have been the centerpiece of many project activities that Len has worked on. Len has received many awards for his work on disability and civil rights and has served on several task forces, commissions, and special government projects. He lectures extensively and has written and co-authored articles, legislation, codes and ordinances, best practice materials, and policies. So, after all of that, we are now going to get started with our questions. I just want to remind our listeners on the line that if you have any questions that you would like our speakers to address, please email them to me at paul@lgbtbar.org, and we'll try to make sure that we get to them by the end of the call. So I think to start, it might be best to have a little bit of an APA 101. So I'm thinking, can you please discuss what exactly the APA is and why it's so important? And perhaps we could start with Ken.
Sure, it's a pleasure to be with all of you, and there's so much to say about the APA. As Paul indicated, I've had 2 tours of duty through the government and worked extensively with a major regulatory agency, and the APA was our bread and butter in counsel's office, and so I, like my co-panelists, have had occasion to really witness its utility in advancing public policy. In terms of your question, Paul, about why advocates should care about the APA, I think you can think of the APA both in offensive and defensive terms. I think that when one is advocating for public policy that is supportive of the LGBT community, one wants to help guide agencies in their policy making to ensure that the policies are crafted in ways that are not subject to challenge. And when I say defensively, I sort of mean, when one is seeing anti-LGBT agency actions, there are many potential lines of attack that the APA offers. And I suspect on this call, given the new era that we find ourselves in, we may be focusing more on this latter potential use of the APA. But it does appear that the APA provides tools both in terms of process-based challenges and substance-based challenges. There are some process fouls that agencies can commit when they issue policies under the APA, and then there are substantive deficiencies if certain basic substantive standards can't be met. If, for example, the policy is arbitrary and capricious. I think I'll pause there because, when you talk about kind of APA 101, there's so much we could talk about, and I'm certainly happy to launch into any number of key principles and requirements, but maybe I should pause and sort of let the co-panelists weigh in on sort of your framing question first.
Yes, Jane, do you have anything that maybe you could add to exactly what the Administrative Procedure Act is and why it's so important?
Well, I guess framing it up from an advocacy perspective, as Paul said, we represent low-income people and other vulnerable populations in both administrative and litigation forums. We use the APA, as Ken has just said, both offensively and defensively, both to get rules in place or to get public awareness of and government accountability for rules that it is using, but that it hasn't really promulgated as it should. So there's that rulemaking aspect of the APA that we use federally, and also remember that states have APAs as well that are modeled, most of them, on the federal APA. And so we also have done litigation in a number of states, California, Florida, North Carolina, Arkansas, where states are using assessment tools or something of that nature to determine Medicaid eligibility for long-term services and supports, but they're secret, they're not subject to public review, and people don't really understand them. Well, those are rules because they're used generally applicably in a forward way to a general population. So we will use the APA to challenge those rules at the state level. And then, as Ken said, there's the quasi-judicial aspects of the APA, which we have used in cases most recently where the federal government has attempted to allow states to ignore provisions of the Medicaid Act to put experimental projects in place that we argued were not experimental and thus were outside of the authority of the agency to approve. So I think just for us, we try to use the APA offensively through both the rulemaking aspects of the APA and usually defensively through the judicial components of the APA.
Great. I'm actually glad that you mentioned both state-level action as well as rulemaking. I know that we'll address that a little bit more a little bit later. But I think that maybe we could talk a little bit as well about when it comes to agency action. I know this is very broad, but maybe you could talk a little bit about what you can challenge and typically what the standing is required in order to challenge. So I'm not sure who would want to answer this first, but we haven't heard from Len yet. So Len, maybe you would like to take the lead on this?
Well, the challenges to the rules can be made on several bases. One, because the agency wasn't vested with statutory authority in the first place to publish the rule or define through its rulemaking particular definitions or take certain actions. Then there's another level which calls upon whether or not the decision and the rulemaking itself was arbitrary and capricious. And so there are different levels of how you can challenge the agency rulemaking, and sometimes adjudication, because oftentimes this is done by an agency using an administrative law judge, and the agency adopts a particular position. So there are different levels of, and one of the questions is how does a court, especially appellate court, review, and what standards does it use when there are challenges either to rulemaking or an adjudication? And I'll leave it to others to talk about what level of deference, and I think the different ways under Chevron, for one, it's how much discretion can the courts apply to a particular agency action, and also whether it's going to, when it's interpreting its own rules, and that's really what's at stake right now, especially with the Gloucester case. And if I can just give an analogy, I just read an article concerning the nominee for the Supreme Court, Gorsuch, and Justice Roberts has always talked about, as a judge, he referees balls and strikes and essentially is on the field in doing them. When you're reviewing rules, though, Gorsuch talked about almost using, I don't like sports analogies, but this just came up on a blog, saying it's more like an instant replay. And the general deference to the agency rulemaking in the past under Chevron is, unless you have incontrovertible proof that the agency wasn't acting within statutory authority, you don't overturn it. So that's basically a very broad overview about what kind of challenges could be made. And Ken and others can fill in the gaps.
I actually think, Len, you've touched on many of the key principles that folks on the phone should focus on when they are considering wielding the APA. I do think a first inquiry is this question, it's ultimately a constitutional question, of delegation. In other words, has Congress delegated to the agency the authority to take the action at issue? That includes the authority of the agency to engage in rulemaking. Agencies do not inherently have the authority to engage in rulemaking. Congress has to grant it to the agency. So there are some really foundational questions that should be asked at the start of any APA inquiry. A next one that Len mentioned, of course, was what type of agency action are you dealing with? One often thinks about regulations and guidance that an agency issues, but as Len says, we should not forget that another type of agency action that the APA governs is an administrative adjudication. And when you're thinking about the difference between regulations and guidance, it's important to understand the distinction, because regulations by their nature have binding enforceable effect, whereas guidance does not. So you want to be sure you're understanding what kind of agency action you're contending with to understand what theories, if any, make sense to deploy. Then there are a series of process-based requirements. So this is particularly true. I guess there are requirements involving regulations. There are requirements involving adjudications. We often think about regulations and the process requirements there. So there, absent good cause, must be prior notice of the proposed policy. There must be an opportunity for public comment on the proposed policy. There must be meaningful consideration given to the comments that are offered. The final policy must be a, quote, logical outgrowth, unquote, of the proposed policy. It can't just materialize out of thin air. So there are a number of process-based requirements, and then there are, various requirements on the adjudication side involving hearings and so forth. But then there are the substantive standards we've talked about. Is the ultimate policy arbitrary or capricious? Is it supported by substantial evidence in the administrative record? And then in making those determinations, as Len said, there's the very important question about the level of deference that we given to an agency in interpreting the law. I'll pause there and let Jane and Len chime in on some of these basic concepts.
Well, this is Jane. I just want to pick up. We're sort of we're winding in and out of the kind of the rulemaking part of the APA and the quasi-judicial part of the APA. Going into to just pick up on something that Ken said in terms of the rulemaking part. I've been old, and so since I have been practicing law, I have seen a greater use by the federal government of the process whereby instead of proposing a notice of proposed rulemaking, which sets forth the proposed rules with a comment period, those comments are received, and then the final rule is published either with explanation for the comments or republished if the comments are significant enough to make significant changes. The federal government has come to operate by not always, but sometimes issuing an interim final rule with a comment period. In other words, the rule becomes effective and there is then a time to comment on it, and the rule may or may not change. Ken mentioned a good cause exception for the prior notice and comment type of rulemaking that I talked about first, not the interim final rule with a comment period, but a proposed rule with notice and comment. That good cause exception is not a broad one. There was just a case reached, within the last couple of weeks in Texas involving some end-stage renal disease regulations that the Obama administration published with an interim final rule with a comment period, and was trying to claim a good cause exception to why it didn't follow normal notice and comment. And I think that ruling and decided in that ruling are going to be very important to us moving forward, as we have a lot of regulations in play and a souped-up number of regulations in play. If the executive order, which we're calling the one-in, two-out order, there's an executive order that was issued that says that for every regulation that's substantive regulation that is issued, 2 regulations must be identified for repeal. And there's a lawsuit brought by Public Citizen to challenge that Executive Order 13771, both on constitutional grounds and on APA grounds. It's not embedded, that type of one-in, two-out notion is not embedded anywhere in the ACA's framework for what you have to consider when you're publishing rules. So I think that case, the dialysis case, and cases like it that are holding the federal government to the strict requirements of the APA and challenges to executive orders that are affecting regulations, the promulgation of regulations and rulemaking will be important to monitor moving forward here. Perhaps we who have, I'll leave it at that.
And this is Ken, just to give one more real-world example of what Jane is talking about, and this is just to give you a flavor of how you as advocates can use the APA in very concrete ways. I think many of you are aware there was a leaked draft of an executive order that has often been referred to as the Religious Freedom Executive Order, and there are many in the LGBT community and beyond that are concerned about the potential actions that are set forth in the leaked draft. One of the items in the leaked draft is a directive from the President to the Secretary of Health and Human Services to issue an interim final rule. So this is a rule without prior notice and comment that would establish a religious exemption from the Women's Preventive Services coverage requirement under the Affordable Care Act. Seemingly, this is directed at the contraceptive coverage requirement, but it's actually drafted to be even broader than contraceptive coverage and encompass all women's preventive services coverage. What, Jane and Len and I and others who, think about the APA noticed immediately is, the President and the Secretary of HHS can't just issue an interim final rule just because they want to do it quickly. In other words, there has to be good cause for bypassing prior notice and comment. So if HHS were to issue an interim final rule and bypass notice and comment in accordance with that directive, if it ever were to issue, I think there would be a very easy APA challenge, for a very easy process file. You wouldn't even need to get to the substance of what happens in that rule. You would say you did not afford prior notice and comment, and the mere fact that you want to move quickly is not good cause. The mere fact that there's been a change in power and there's a new philosophy, that is not good cause. So as Jane is saying, there are real ways that even this one very seemingly obscure prerequisite under the APA can be wielded in situations where there's something tremendously substantial at stake.
And I think in law school we're really taught to read cases. One of the things we haven't really been good at, we've been parse statutes, but we really haven't been training people to read regulations with the same kind of detail and looking exactly at what's being said in the Federal Register. We tend to be more accepting, I think, of regulations as if they're a given. And what Ken and Jane are saying, because there are many examples of this, but the EOC rule, proposed rule about the sexual orientation and gender identity being protected and non-discrimination under the Office of Federal Contracting and Procurement, started just like the Department of Education rule and the HUD rules about gender identity and sexual orientation. They're rooted in an executive order, and they say there's no notice and comment because the good cause, and this is what the new administration will frame it as, there's no need when it's impractical, unnecessary, and the catch-all that I'm concerned about is or contrary to the public interest. And then they give the authorities for that. And I think we just as a profession have to really examine everything in these published in the Federal Register as well, because right now we have been relying on an administration that is using an executive order in the way that we protect our client communities. And that's shifting.
That religious exemption executive order could come out this afternoon. So,
and there's a companion
rather than later.
And the third legislation, and this is the second time around, is the Separation of Powers Restoration Act, which would remove from the courts any kind of deferential standard to agency rules or adjudication. It would say they conduct a de novo review and they do not defer whatsoever to agency when they're reviewing their own regulations or when they're reviewing their statutory power. So that would eliminate most of the protections we count on from judges to scrutinize agency action.
And just to add one more observation about the leaked draft of the Religious Freedom Executive Order, there are, of course, directives that more squarely are targeted at the LGBT community. And, those of us who are thinking about potential challenges to the directives should they issue are thinking beyond just constitutional theories. There are actually APA and APA-related theories as well, because although, the language is not as clear as it could be, it appears that the directive would have agencies establish policies that are in contradiction to existing final rules without undertaking notice and comment rulemaking to modify those existing rules. Similarly, some of these directives would appear to direct agencies to establish policies that are in violation of statutes. And, and obviously an agency could not purport to abrogate statutory protections through agency action. And again, that would seem to implicate some of the basic notions that underlie the Administrative Procedure Act. Paul, there was
Awesome,
one part of your question that I don't think that we addressed, and I think you had asked something about, if I remember correctly, standing to challenge agency action, something along those lines. And I just wanted to make two quick observations on that. So there are obviously things to think about if you are thinking about bringing an APA-type challenge to agency action. And this is not meant to be an exhaustive list of the considerations, and I'm sure Jane and Lynn can say more, but there are some limitations. First of all, the agency action has to be final, and there's a lot of case law about what constitutes final agency action. And so you'll want to be sure that you are teeing up a challenge where you may permissibly challenge the agency action at issue. And it gets trickier when you're attempting to challenge guidance versus regulations, for example. Another thing to think about is in some jurisdictions, courts have ruled that when there's a rulemaking, and if you believe that the policy is, arbitrary and capricious, and if you fail to make a comment to that effect during the comment period, you have waived your right to challenge. Now, that is not a universal proposition across all jurisdictions, but it does suggest that we as a community should be watching when there are rulemakings initiated to ensure that the record that is created around those rulemakings reflects, the views of the community. And Jane and Lynn, you should feel free to add or comment on that.
Just to flip to the quasi-judicial or side right quick on standing. What we do, and I don't know, maybe you don't have to, but in where we are litigating an agency action based on a record, our clients have Article 3 standing. That is, they have a harm that is fairly traceable to the federal agency's action that, if addressed, will address that harm. That's not a very good statement of Article 3 standing, but you get the picture. So in a case we did in Arizona against the Department of Health and Human Services for approving very high co-payments for people with incomes below the federal poverty level and mandatory co-payments. So if you didn't pay the co-payment, you could be denied the service. The federal government approved Arizona's request to decide to on that with that provision, and so our clients who were below, our clients were all people who had income below the poverty level. One gentleman was a cab driver who had AIDS. Another was a woman who made her income by picking up cans by the side of the road and taking them to the recycle center for, get paid by the pound. These people depended on Medicaid coverage and couldn't afford the co-payment. So they were our plaintiffs in that challenge to those co-payments, and they were arguing that there was a 35-year track record of study of co-payments that consistently, repetitively concluded that, not surprisingly, high co-payments caused low-income people to forego even necessary care. And the court found these people had standing and also ruled that that the record in the case did not show that these co-payments had any experimental aspect to them, and so reversed the federal agency's approval. So I think in the end, so the quasi-judicial aspect of it, you need, I think, for us at least, we try to move forward with compelling cases of people who are being harmed by the agency action. Sometimes it's very clear. You have an agency record, you've had a hearing. Other times, as in these types of cases that I'm talking about with these experimental, what they're called Section 1115 waivers, you don't necessarily have that kind of hearing, but you do have a record.
I think just to apply some of what Jane said to the rulemaking, taking a tip from lawyers that represent energy providers, drug companies, and labor, they get other people as plaintiffs. The list when they were challenging the overtime regulation included chambers of commerce, large employers, small employers, workers who didn't fit the category. And I think that's a strategy that we may have to pay more attention to with an administration who's going to be withdrawing some of the protections through rulemaking or informally.
Yes, thanks for bringing up that conversation about standing, because I think that has really added a lot to this conversation. I wanted to ask a couple more questions, but I actually think since we're running low on time, I want to start addressing a couple of the questions that I received by email by some of our listeners. So the first question that I want to get to is actually related to healthcare. The question reads, how do you see the appointment of Tom Price affecting access to healthcare, especially for LGBT persons? Do you anticipate a rollback of visitation rights in hospitals for LGBT partners and families? I think that's a very good LGBT-related question to address, and so perhaps, Jane, would you like to take the first attempt to answer this question?
Well, I will take the first attempt, sure. I think that Secretary Price could have a significant effect on health care writ large, and particularly on health care access and services for low-income people and vulnerable populations. Certainly, his views on the Affordable Care Act, his views on the role of Medicaid are known. I would also be concerned and monitor the positions he takes with respect to the range of vulnerable populations and hospital visitation, women's reproductive issues. I just think I would just say we certainly are on high alert across the range of issues and are concerned.
And this is Ken. I mean, my observation is similar. I mean, obviously, access to coverage as represented by the Affordable Care Act is of, great concern to the LGBT community, among others. And obviously, the sense is that Secretary Price will be taking a leadership role in at least significantly modifying the current scheme. And the concern, of course, is that might lead to a diminishment in coverage. I do think that something else to watch for are conscience clauses, religious exemptions, et cetera, in a variety of areas. So that's something I know our community thinks about. One additional particular provision under the Affordable Care Act that I think we're all waiting to see how its implementation is affected is Section 1557 of the Affordable Care Act, which is the new civil rights provision that applies in the healthcare context. And the prior administration issued a final rule that makes clear that its protections regarding sex discrimination include protections involving gender identity and sex stereotyping discrimination. And that is currently codified in a final rule, and of course to be modified would have to go through a rulemaking process under the APA, as we've discussed, to be modified. But the question is, whether the new leadership would see fit to change its interpretation of what sex discrimination means. And as Len was alluding to earlier, we were already seeing hints of, not even hints, of that in the context of the directives from the Department of Education and the Department of Justice with respect to Title IX and the rights of transgender students to access gender-appropriate restroom and other facilities. And, as anticipated, we're already starting to see a rollback of the guidance that the prior administration put out in that regard.
I think on 1557 as well, not just a concern over the scope of 1557 in terms of protected population groups, but also in terms of the subject matter that 1557 will be considered to affect. Our office in the AIDS Institute in Florida a couple of years ago brought an OCR complaint under 1557 against 4 health insurance companies in Florida who were placing medications for HIV/AIDS on the highest drug tier, meaning that they held sharing and similar cost that could be imposed. And 1557 was, we used that statute, and the Florida Department of Insurance stepped in and got the 4 plans to change their ways, but also the federal government issued tiering policies that are designed to avoid that kind of structure. And if 1557 isn't given aggressive implementation by Secretary Price, those kinds of nut and bolt protections could be lost as well.
The issue about visitation, I would also look to state law, because sometimes that gives much greater protections with regard to visitation, relationships, substitute and surrogate decision making. We're now a one-party state, so we're worried about statutory change as well, that they may just change the law rather than waiting for an agency, because they are pushing bills through that mirror what's going on in the federal government now that all branches have a similar philosophy. One other caution, Seth Waxman, the former Solicitor General, was talking about their, not directly on the issue of whether sex discrimination includes, on the basis of sex includes gender identity and sexual orientation. And he was likening issues to that there are some issues that are too big to defer at all to Congress on, let alone the agency. And he gave an example saying that he always thought that the Food and Drug Administration and the federal government had the power to regulate tobacco. And this idea about what Congress had in mind when they were talking about on the basis of sex, that they may not defer at all to the agency, or saying that Congress was clear enough in Title IX. So those are some of the bigger picture issues that frighten me, and what the court's going to do when it gets these major issues of statutory interpretation in front of it.
One thing I'll just add on hospital visitation is that to participate in Medicare, the general rule is that hospitals must be accredited, and there are external accrediting bodies, and I believe that many of them have pro-LGBT accreditation standards. So there may be a bit of a backstop there, even if CMS were to roll back its conditions of participation. But, it is something, of course, to monitor.
Thanks for answering that question so thoroughly. We are basically out of time, but Darcy Chemnitz has a very quick question for all of you.
Not surprising, the executive director has something more she wants to say. I take this subject with keen interest because of my background in personally within the environmental protection movement, and environmentalists use this law, to my opinion, very effectively, and have used it for quite some time. And I was really kind of hoping, after the news of the world these last few months, that we would see this as kind of a great opportunity for lawyers who are not as familiar with the APA to see some light at the end of the tunnel. Is there any possibility, Ken, Professor, others, if there's a way that you could just leave us with a word of what's your most positive view of the APA, or what you would encourage new or young lawyers to be looking for when they look at this law?
Well, I can start. I think that if you're thinking about upcoming changes in federal policy, I think, I would say that we all just need to be vigilant to see what those changes are. And then an analysis can be done in any given case about what theories can be brought to bear to challenge any anti-LGBT policies or rollbacks of pro-LGBT policies, including the APA. And I just think the APA should be, part of that thought process and discussion, because it does, touch on so many aspects of what federal agencies are permitted to do. And then I would also just say, as was mentioned earlier in the call, there are state equivalent APAs, and there are surely ways in which those state APAs can be deployed even now. When I was a litigator at the ACLU, you would think of the ACLU as bringing constitutional claims, and of course that's what we did. But as a former government official, I actually at one point said we were challenging a Missouri policy that precluded foster parenting by lesbian, gay, and bisexual people, and we ended up framing the claim, because I was sort of suggesting actually this lends itself to an APA framing. We actually ended up framing the claim under the state APA and winning under that theory, because the foster care license had been denied to a lesbian applicant. She had gone through the administrative appeals process. She had a right of judicial review in the state courts. And we framed our theories under the state APA. There was not substantial evidence in the record to support the denial of the license. The reasoning was arbitrary and capricious. We could include our constitutional theories because, by definition, something that's unconstitutional is arbitrary and capricious. So there are ways, I think, both at the federal and at the state level, these theories can be deployed.
This is Jane. I would just say very quickly to add on to that for some of these issues that are rising out of the administration, the regulation or the activity is affecting a program that is otherwise at risk, Medicaid being a prime example. And where things are done wrong or it needs to be checked, but it can get quite complicated and so I would just caution to go through the thought process of choice of forum, state versus federal court, and how, if a federal action is brought, I think people may, especially, sometimes you just want to go run into federal court, but maybe that's not the best thing to do if the case is going to be turned around and used as a part of the attack against the Medicaid program or some of these other programs that are under threat federally. So just be wise in terms of putting litigation together. You can get a result from a state court versus a federal court. You can get a result quietly versus loudly.
Jane, I think that is a really thoughtful and important response. I've seen that in action in cases that I have been involved with in the past, and I'm very concerned that we don't have the infrastructure, even throughout the LGBT-specific part of the social justice movement, to be working in concert and collaboratively that the APA kind of demands in a way that maybe other laws don't. And so I think that that's a real challenge there, and thanks for sharing those views.
I think this is Len. I think there are many more networks. We're just sort of fragmented right now. People working with the ACLU, people working with people on the East Coast, the Midwest, but we don't advertise or publicize for a variety of reasons. Just looking at the state, because part of this is what's in our toolkit as advocates. And I'll just give you one of the issues we're working on is seclusion and restraints in schools, especially as applied to LGBT, kids with disabilities. So you don't need to have a client to file a state complaint or a federal complaint so long as it states a claim about the use of boxes or a violation of federal law or state law. At the same time, every 5 years, agencies have to review their rules, and anyone can file a petition for rulemaking, which is being done in tandem with the state complaint to try to make sure that the state agency, which gives broad discretion to local school boards, the state agency publishes rules that really detail when it can be used and when it can't be used, and at the same time using community groups to address local school board practices and bring it to light in the media. And someone filed a bill without us even knowing it, and that's where I think the danger is of not having coordination. We were sort of ambushed that someone was filing a bill and we had no idea of it. So there is a lot of power available, and welcome you to exercise it.
And we were just chuckling here at the LGBT Bar staff about finding out that people are dropping bills because you read about it in the press, even though you might be all over the internet being experts in that given area. So we're certainly familiar with that here. I know Paul needs to close out this call. Thank you so much for giving us your thoughts. Go ahead, Paul.
Yes, thank you. I again just want to thank Len, Ken, Jane again for taking the time out of your day to speak for this call-in, and thank you to all of our listeners for calling and listening in. The National LGBT Bar Association cannot continue putting together quality programming like this call without your continued support. If you'd like to see more cutting-edge legal analysis, please consider becoming a member of the bar or renewing your existing membership. To learn more, please visit our website at lgbtbar.org. Thank you.